A common question I receive is there a large benefit of being the petitioner versus the respondent? The lawyerly answer would be, well, it depends. One of the benefits of being the petitioner is that if you end up in front of a judge, you're going to be the person that speaks first. You're going to be the person that gets to dictate the initial flow of testimony and of evidence presented to the judge. At the same time, even if you're the respondent, you'll still get to give your piece and you'll still get to tell your side of the story, but the judge will have already heard the other party's side of the story first. However, sometimes it can be emotional to be the person that actually files the case. Maybe you're going through some heartache and headache and you can't decide whether or not it's worth it to you to file the case at that time. That's okay. If you end up being the respondent in the case, it doesn't mean that you're behind the eight ball. It just means that the other person's going to get to speak to the judge first if you actually end up in front of the court. With all of that being said, both you and your spouse or the parent of your child, you can always work together a deal where you're not ever to talk in front of the judge at all. But again, that's just going to depend on how well the two of you are able to co-parent or how willing the other parent is to not have their story heard before the judge. If you have more questions about how the court process works or whether or not you need to be the person to file first, feel free to give me a call. You can contact our office at 817-900-3220, or you can reach out to us via our website at familytexas.com.